Hello to you all, and thank you for joining Mayor Brown's webinar today. Benefits and Compensation University, ERISA Title I Developments, Litigation, and Governance Trends. This is the third of 4 webinars in Mayor Brown's Benefits and Compensation University 2022 series. Today we are going to cover the current litigation environment over 401k plans and 403b plans. We are also then going to talk about some of the trends that we are seeing as far as fiduciary best practices in light of the current litigation environment. My name is Nancy Ross. I am chair of Mayor Brown's ERISA litigation practice and a partner in our Chicago office. And I am happy to introduce my colleagues for today's program. Joining me today is my partner, Aaron Cho, one of the firm's employment and benefits practice in Washington, D.C., one of the partners in the firm's employment and benefits practice in Washington, D.C., who focuses on ERISA Title I fiduciary matters. With Aaron to discuss trends is Erica Gasker. Erica is a partner in the ERISA fiduciary and fund formation and investment management practices in Mayor Brown's Chicago office. And last but not least, we have my partner, who litigates with me these cases, Brantley Webb. Brantley is a litigation partner and also a member of the firm's Supreme Court and appellate practice, and Brantley is in our DC office. Before we begin, I'd like to cover a few administrative matters. First, if you are applying for CLE credit, we will provide an alphanumeric code during the presentation. Please record this code on the CLE affirmation form, which can be found in the connection details email we sent yesterday. The form will also be emailed to you within the next day or two following our program. The email will also include links to a recording of today's program and an evaluation form. The evaluation form can be found in the same file as the CLE form. Even if you are not applying for CLE credit, we'd really appreciate it if you would complete the evaluation so that we continue to provide meaningful content. If you have any questions during the presentation, you can let us know via the Q&A feature on the bottom of your screen, where you can type your question into the Q&A box. We will do our best to address questions live or after today's program. With that said, let's begin. So, the beginning of the year saw what we had hoped would be a meaningful development by the United States Supreme Court as to what was required to bring one of these lawsuits challenging 401k plans. And when I say 401k plans, I'm also talking about 403b plans. So as most of you know, in the past 3 years, we have just seen a cascade of these lawsuits. And the courts have not been much help because they have been all over the map on whether they dismiss that cases early or they let them go. And the default by the courts was to let them move forward into discovery, which we know is a very expensive stage. So, change the slide. The Supreme Court granted certiorari in a case that was brought against Northwestern University. Don't be confused by the switch of the name before the Supreme Court. The lower court opinion was the plaintiff was Devani, but Ms. Devani decided not to participate in the Supreme Court case. So what happened there? Well, Northwestern is in my backyard in Illinois, in the suburbs of Chicago. So the case there was filed there, and after a exceedingly long time, the district judge tossed the case on Northwestern's motion to dismiss. Plaintiffs weren't happy with that, and they appealed up to the Seventh Circuit Court of Appeals, and they were met with the same fate. For those of you that practice in this area, you may know that the Seventh Circuit has historically been a pretty favorable place for employers and companies and fiduciaries to defend these cases. And so in keeping with its past precedent, the Seventh Circuit affirmed the district court's dismissal of the case. And what was the issue? So plaintiffs were alleging, among many things, but their main allegation was that defendants offered too many investment options, that they provided overly expensive investment options, and that they provided high-cost retail share classes for certain investment options, and finally, that they paid excessive record-keeping fees. So the case ran the gamut, covered all the general allegations that we tend to see in these cases. When the Seventh Circuit affirmed, it found that the plan sponsor did not violate its ERISA fiduciary duties because the plan also included prudent low-cost investment options, which plaintiffs did not dispute. So in my view, the Supreme Court interpreted the Seventh Circuit decision wrong, and the Supreme Court saw the Seventh Circuit as really saying, if you have prudent investments among imprudent investments, you're okay. That you cannot be deemed imprudent. And the Supreme Court didn't like that, primarily because, you switch the slide, please. Primarily because the Supreme Court interpreted ERISA and fiduciary duties as requiring that all investments be deemed to be prudent. So it was not going to work to say, well, it's okay to have a few bad apples because we have other good apples. So frankly, a bit to our surprise, the Supreme Court issued a unanimous opinion. It was 8-0. Judge Barrett recused herself since she was formerly from the Seventh Circuit. And the opinion was very short. It was 6 pages. And I think for both defense and plaintiffs, it's fair to say it was a complete disappointment. So the defense bar had been very optimistic that the Supreme Court was going to hand down some instructions as to what plaintiffs must plead to get over the hurdle and enter into discovery. And it really did nothing of the sort. It reversed, the Supreme Court vacated the decision. It remanded it to the Seventh Circuit for the Seventh Circuit to reconsider whether plaintiffs had plausibly alleged a violation of the duty of prudence. So the Supreme Court did not go any further, which is not unusual because it tends to, like the lower courts, to have the first shot at resolving the claim. But we the defense bar, I think, was hoping that we would get more of a decision that was along the lines, for those of you that remember the company stock cases and the Supreme Court's decision in the Fifth Third Bank case, where the Supreme Court put a pretty onerous burden on plaintiffs to be able to plausibly plead a stock drop case. And we saw shortly after the Fifth Third Bank's case that company stock cases in the ERISA arena really dried up. And so we were really hoping that we were going to see something like that. We did not. So Hughes is still pending on remand with the Seventh Circuit. So we don't have resolution on that case. Next slide, please. However, we are encouraged from a defense standpoint on some of the circuit opinions, as well as the district court opinions, but circuit court opinions have more precedential value in that they are binding, at least within their own jurisdiction. And we started seeing some really good decisions by courts of appeals. Next slide, please. So although Hughes is still pending, the Seventh Circuit did issue its opinion in the Albert versus Oshkosh Corporation case. For those of you who watch the press regarding these cases and litigation, you may be familiar with a guy by the name of Paul Secunda. Paul Secunda has more recently come on the radar over the past couple of years, and he still is filing a number of these lawsuits. I think he's probably got more than a dozen right now. So the Oshkosh case was one of Paul Secunda's cases. And in that case, the plaintiffs alleged, among other things, that the defendants breached their fiduciary duties by authorizing the plan to pay unreasonably high record-keeping fees and failing to ensure that each investment option was prudent. So kind of your standard generic claims that we see in these cases. The Seventh Circuit held that the plaintiff had failed to state a claim on the record-keeping fees because, and this has turned out to be very important and a trend in the cases, the complaint did not allege that the record-keeping fees were excessive relative to the services rendered. And that became sort of a pronouncement by other circuit courts as well, that you cannot judge record-keeping fees in a vacuum because you need to understand what the fees are for. The Seventh Circuit also reiterated that merely charging higher fees for actively managed funds are funds that strive to be an index over passively managed funds. So what the Seventh Circuit said is that merely charging higher fees for actively managed funds than for passively managed funds ordinarily is not enough to state a claim. What the court said is, quote, defendants failed to consider materially similar and less expensive alternatives to the plan's investments option without more detailed allegations, providing a sound basis for comparison was not sufficient. Next slide. So we are optimistic in the Seventh Circuit jurisdiction, Wisconsin, Illinois, Indiana. Try not to embarrass myself. I think that's it for the Seventh Circuit. Let's now turn to the Sixth Circuit Court of Appeals. Sixth Circuit being the court that hears appeals that are from the district courts in Michigan, Ohio, Tennessee. I think I got that right. I know I got that right. There may be others that I'm forgetting. So in both Common Spirit, Smith versus Common Spirit Health, and a second case, Foreman versus Tri-Health Inc., and these came down very close together, the Sixth Circuit had a lot to say, and it wasn't buying these claims with one exception. So in Common Spirit, the Sixth Circuit affirmed the dismissal by the district court of the plaintiff's record-keeping fees claims. Again, it found that the complaint did not allege that the fees were excessive relative to the services rendered, so keep that in mind. And it also found that the complaint The Sixth Circuit additionally rejected plaintiffs' attempts to compare actively managed funds and passively managed funds. The Sixth Circuit said that comparison is apples to oranges. Foreman then trailed Common Spirit, and in Foreman, the Sixth Circuit largely relied on Common Spirit to reject the plaintiff's claims that the plan expenses were excessive and that the plan should have included alternative investments with lower fees and higher performance. So the Sixth Circuit rejects those claims. However, the Sixth Circuit did reverse the dismissal of one claim, and that claim was that Tri-Health violated the duty of prudence by failing to offer share classes that were less expensive. So when we get into trends, you're going to hear from Aaron and Erica, and one of the trends is to look and see if the funds that you are offering do provide a institutional share class, and does your plan qualify for it? So that is a, if your plan is too small, that is a material factor to the courts in addressing these. But the Foreman case did keep the share class claim alive. Then we get to a decision that came down just last week on October 12th. That one was in the Eighth Circuit Court of Appeals. That's Minnesota and surrounding states, Iowa. And at that case, Matusek versus Mid-American Energy Company was very exciting for the defendants in these cases, because in that case, the Eighth Circuit affirmed the district court's grant of Mid-America's motion to dismiss after finding that the plaintiffs had failed to plead meaningful benchmarks for assessing the performance of the challenge funds. And one thing I want to interrupt myself to say is that some of these cases are challenging cost. Some of these cases are challenging performance. Brantley's going to talk to you about the recent spat of BlackRock TDF funds, cases challenging those that really focus on costs, saying that they paid, fiduciaries have paid too much attention to cost, and in the process sacrificed prudence, sacrificed performance. But Brantley will tell you more about that. For the record keeping claim in Mid-America, the panel said that the Eighth Circuit had been clear in the past, and this is a quote, that the key to stating a plausible excessive fees claim is to make a like for like comparison. Again, you can't assess record-keeping fees without knowing what services are being provided. The Eighth Circuit also found that the comparator peer group funds, so that's how the plaintiffs load up their complaint. They try to give examples of benchmarks or comparator plans that they offer as benchmarks. There's, a tremendous amount of cherry picking that goes in to the assembly of their complaints. But what the Eighth Circuit found was that the comparator peer group funds lacked sufficient information to know whether they were meaningfully similar to the challenged investments, such as they lacked information about whether the two different groups held similar securities, had similar investment strategies, or similar risk profiles. So we're finding that there has been a lot of rejection recently over plaintiffs' comparator funds that they put into their complaint. Okay, next slide, please. So that's the good news. The not so good news comes out of the Ninth Circuit Court of Appeals. That covers California, Arizona, Washington, Oregon, Hawaii. And in the Ninth Circuit, there were two cases that went up on appeal that had both been dismissed by the district court. One was against Salesforce, the Davis v. Salesforce.com case. The other one was against Trader Joe's, a place that we all probably know well, Kong versus Trader Joe's. The district court had dismissed both of those lawsuits on grounds that the plaintiffs had failed to provide meaningful benchmarks. But up on appeal in Salesforce, the Ninth Circuit reversed the dismissal of the plaintiff's claim that defendants imprudently failed to select lower cost share classes. So again, it's that share class issue. It also reversed the duty to monitor claim. That tends to be derivative of the primary claim, claiming that the fiduciaries failed to monitor, or the appointing fiduciaries failed to monitor the fiduciaries that were responsible for running the plan. And the Ninth Circuit reversed the dismissal of the plaintiff's claim that defendants imprudently failed to investigate and timely switch to available collective investment trusts. Erin will talk to you more about CITs later in the program. The Ninth Circuit found the plaintiff's allegations regarding lower cost shares and that the question of whether the regulatory regimes governing mutual funds and CITs justified retaining higher cost mutual funds should be left to summary judgment. Then you have the Trader Joe's case, it involved a different panel from the Ninth Circuit. That panel employed a similar reasoning to resurrect comparable claims involving Trader Joe's 401k plan. There, the Ninth Circuit found that the complaint plausibly alleged a failure to provide cost-effective investments with reasonable fees where, and watch for the common trend here, plaintiffs alleged defendants offered mutual funds with retail share classes that carried higher fees than institutional share classes of the same investments. So share classes has remained out there. And again, I think one of the quick ways to argue against a claim like that is to check and see if you even have the threshold asset level to qualify for those funds. Next slide, please. Now I'm going to turn it over to Brantley, who's going to talk to you about some of the district court decisions that we've seen since Hughes was decided. Brantley?
Thank you, Nancy. So there are many, many district court decisions of note from this year. We've tried to pull out a few of the most notable to highlight for you, 2 from before Oshkosh and 2 after Oshkosh. the significant landmark this year after Hughes. So first is Riley versus Olin Corporation, which was decided on June 21st, 2022. The defendant's motion to dismiss was granted in that case. Plaintiffs included the two big excessive fee claims. One, the record-keeping fees were too high. Here, there was revenue sharing in the plan. And two, the investment management fees for particular funds were too high. I like to think of this as sort of this, the plaintiffs took a survey approach in this case for both the record-keeping fees and the investment management fund fee claim. The plaintiffs compared the plan's fees to other fees detailed in surveys. So with respect to the record-keeping fees, they compared the plan, the fees that the plan was paying to fees listed in the NEPC survey, which surveys 100 or so plan record-keeping fees. And for the investment management fees, they compared those fees to fee categories detailed in the Investment Company Institute report, which some of you may be familiar with, where the Investment Company Institute surveys investment fund fees and comes up with average fees for broad categories of funds like domestic equity funds or TDFs, that sort of thing. The court flatly rejected this approach. It described the material before it to say that it did not need to accept as true the plaintiff's legal conclusion that these surveys are meaningful benchmarks. It found with respect to both surveys that they lacked the necessary detail. So with respect to record-keeping fees, that meant the survey didn't include detail about the actual services that the plans, record-keeping services that the plans had signed up for. And with respect to the investment funds, the ICI report lacked detail beyond just designating the broad category of fund, like an equity fund or an index fund or a TDF. So that case is a good reference point. If you're in a complaint that you're looking at, the plaintiffs are relying primarily on survey data. That was before Oshkosh. One other important district court decision before Oshkosh is Mature versus Wesco Distribution. That was decided in the Western District of Pennsylvania in April. In that case, the court granted the defendant's motion to dismiss. That case focused on record-keeping fees. We wanted to highlight this case for you because plaintiffs took an interesting approach. They essentially tried to put the burden onto the defendants with record-keeping fee allegations. They alleged that the record-keeping the record-keeping services that the plan had signed up for were sort of standard and general services that all similarly situated large plans received. And the plaintiffs claimed that the defendants must show that the record-keeping services provided to the plan were special, unique, superior, that would justify excessive fees. So the court also rejected this outright. It found that the plaintiffs have to provide the detail. They can't punt the burden to defendants. They have to provide the detail on the services that the plan is receiving and the services that the comparator plans are receiving. This is a case where, like so many this year, the plaintiffs have included that chart that lists out, plan, size of the plan, record-keeping fee, and a list of 5 to 10 comparators. The court rejected that, said they were cherry-picked. They weren't similar enough in size and assets under management to be meaningful comparators. This is a case also that discusses the way that plaintiffs calculate fees from the Form 5500s. We're not going to go into detail about that today. It's very technical. Sure, many of you are familiar with it, but plaintiffs often use the Form 5500s to calculate out alleged fees that plans pay. It's often inaccurate because it's fairly hard to tell from the Form 5500s. From the Form 5500, the exact fee amount per participant that a plan is paying unless it's stated unless that is stated itself in the Form 5500. So the court in Mature critiqued that calculation that plaintiffs had made. Let's turn to the next page. These are two cases, Exelon and Univ are two cases post Oshkosh and decided September of this year. I think they're useful because the courts are reacting to Oshkosh. So in Exelon, the court finds specifically that the Seventh Circuit in Oshkosh had narrowly interpreted Hughes and clarified the pleading standard within the Seventh Circuit. The court went on to reject the plaintiff's comparators. So as Nancy said, Oshkosh focused on that issue. In Exelon, the Northern District of Illinois court focused on that same issue, found that there were not specific enough allegations about the services that the plan received for record keeping versus the services the comparator plans received for record keeping. Same with respect to investment advisory services. That complaint had also alleged excessive investment advisory fees, taking the same approach to record keeping of just comparing different fee levels between plans without detailing the specific investment advisor services the various plans were receiving. So the court rejects that. One thing I thought was interesting from this opinion to note for you, the court, the plaintiffs had highlighted the fact with respect to a particular investment fund that was challenged in this case. The plaintiffs had highlighted for the court the fact that the plan had removed that fund and that showed that that fund was imprudent, that helped support their claim. And the court actually went the other way on that. And it found that the fact that the fact that the plan had removed that fund actually showed a prudent process and thoughtful consideration. Turning to Univ, this case actually came out the other way on record keeping fees despite Oshkosh. It accepted the way that the plaintiffs had used the Form 5500s to calculate record keeping fees. But on investment funds, it followed the Oshkosh approach and rejected the allegations as providing insufficient detail to make a comparison between the plan's funds and the comparator funds. So here it cited the common spirit decision. It found that the plaintiffs were improperly comparing actively managed versus passively managed funds, rejected outright this notion that TDFs, for example, are all considered actively managed. So those are the highlights from the district court. If we had more time, I'd love to go into more, but I want to move on to the next segment if we flip the page. I want to talk really quick before turning it over to Aaron and Erica about how plaintiffs have reacted to Oshkosh and to common spirit. So what we've seen is actually a lot of amended complaints in the wake of those decisions where plaintiffs have attempted to bolster their allegations. I'll highlight record keeping fees. One thing we've seen is, because it can be difficult to figure out exactly what, well, I shouldn't say difficult, but it can be tedious to figure out exactly what services, administrative and record keeping services a plan is receiving. Plaintiffs are alleging sort of a new theory, which is that all large plans receive the same record keeping services, bar none. Nearly identical base services. And they list out what those are, transaction processing, participant communications, things like that. And then they allege that the plan received these base services. So in this way, plaintiffs amended, we saw multiple complaints amended to try to get around Oshkosh's requirement of alleging the specific services that the plans and the comparator plans received. just to note on that, one way to deal with that on a motion to dismiss is to go into the Form 5500s and to look at the service codes for the actual services the plan is receiving. That can be tedious, as I said, but that is one way to actually research this issue and put it to rest as needed.
Okay. Sure. Another point on record keeping fees, if you're a fiduciary committee looking to engage a record keeper, you should inquire how much the record keeper is being paid for using plan participant data. This point has come up in some of the earlier litigation, especially that was filed by the Schlichter firm. And what that means is record keepers have a lot of information about plan participants, how much they, put away in their 401k plan each month, whether they have loans under their 401k plan, and they provide that information and data to other service providers that may provide financial wellness services, college loan services, and those service providers will market their services and target certain plan participants. And the record keeper may get a cut or of compensation to the extent that any participant engages the service provider for those services. So it's important to at least get on the record that you have asked that question of the record keeper. Some record keepers will resist providing that information, but in my experience, we've been able to get that data and information and then use that to negotiate the record keeping fee. So that's one practice that we've been, we would advise.
You can also use it to require the record keeper to not engage in the conduct.
That's true.
Some companies are doing that and they are putting it into the record keeping agreement.
That's right. That's right. You can shut it off.
So one more quick note, and I want to turn it over to Erica. Two issues where we would say across the circuits, the jury is sort of still out at the motion to dismiss level are the share class claims and the CIT versus mutual fund claims. Nancy already talked about the share class claims and how Ninth Circuit has allowed those to survive. I think we've seen that in a lot of district court opinions as well. Another interesting issue is CITs versus mutual funds. And with respect to that issue in the Olin case, the court addressed it and noted the Salesforce case and ultimately found there weren't enough allegations on that claim, but sort of credited the general concept that if a CIT is cheaper, should a fiduciary consider switching from a mutual fund to a CIT? So didn't reject plaintiff's claim conceptually, but found there weren't enough allegations around it. So with that, I'll turn it over to Erica to talk about CITs and mutual funds. Sorry, let's go to slide 18 for that.
All right, thanks, Brantley. Next slide, please. Just to give a sense, as far as, all this litigation over fees and CITs, 401k plan sponsors actually have started to move money into CITs. And so we just wanted to basically explain why collective investment trusts, how they compare to mutual funds. And the reason why CITs are appealing is cost. They generally have lower overall costs than mutual funds because the CITs have lower marketing costs because CITs are not marketed to the public generally. CITs do not have SEC filing requirements that mutual funds do. CITs also do not have board of directors, and they typically have lower overhead. And in addition to just lower cost overall, with respect to the share class issue, CITs offer more opportunity to customize your fee arrangements based on plan size. And this because, again, they don't have filing requirements with the SEC. So if a mutual fund wants to create a new class, it has to go through a whole process, whereas a CIT has much more flexibility to negotiate different fee arrangements based on plan size. So that's also appealing given the the quickness with which that can be done. And another appealing aspect of CITs for any type of retirement plan investor is that a CIT, once it has $1 of ERISA in it, is subject to the ERISA standards of care, the prudent person standard of care. Mutual funds are not. Next slide, please. And here's just some key features we just wanted to give you access to. Again, comparing, this is how collective investment trusts are managed. So they are by a bank or trust company. In contrast, mutual funds are generally managed by asset management companies and are available to every type of investor. A distinction here that I want to make is CITs, really are only available to retirement plan investors. So there is a limitation there. And that's highlighted on the next slide, please. So you see there the investor eligibility for a CIT is up at the top. So that, again, is something that is a difference with respect to mutual funds and CITs. And with that, I will turn it back, given our time constraints, to Brantley to start talking about the BlackRock cases.
Thanks. So staying in the investment world, we've pulled out a case study, so to speak, for you, focusing on approximately a dozen lawsuits that have been filed in the last few months concerning BlackRock LifePath target date funds. So these have been filed against large corporations who include the BlackRock LifePath TDFs as investment options in their plan. The plaintiffs have a novel theory in these cases. As you know, over the last few years, we've seen maybe 100 complaints that have alleged that a plan should have included a lower cost passive investment option instead of a more expensive active investment option. These cases take the opposite approach. As Nancy previewed, the plaintiffs allege that the defendants chased low fees without considering returns and performance. So these are really sort of one-shot complaints. They really have one claim in each case, which is that the BlackRock funds were cheap, but they completely underperformed 5 of their peer TDFs. And the plaintiffs have cherry-picked 5 TDFs, 5 of the top performing TDFs over the last 5 or 10 years as comparators, without looking closely at the distinctions between the BlackRock LifePath TDF and the comparator funds. A couple of motions to dismiss have been filed already in these cases. And in general, the defendants have made the arguments that the comparator TDFs don't provide meaningful benchmarks. They're meaningfully different. The performance differences are not very significant. And indeed, very recently, the BlackRock LifePath funds have outperformed some of the comparators. They also cite some of the ratings that the BlackRock TDFs have received by Morningstar. This suite of cases, I think, raises one of the quintessential questions that ERISA defendants face at the motion to dismiss stage, which is, how much do you want your motion to dismiss to look like an expert report versus trying to really speak in the plainest possible language to the judge? And I think it's a tough balance to strike, particularly in these cases and in other cases that raise these types of investment claims. I think, if you're trying to distinguish active versus passive investment strategy, that's well covered territory in the case precedent. Courts understand that at this point. But in some of these cases, defendants will face choices about getting into detail about different types of glide paths, different types of holdings, those sort of more technical issues that I think can be very hard for a court to digest at the motion to dismiss stage and can be a turnoff. In general, as we think about it here, when we're Nancy and I are litigating, it's important, I think, to try to weave in higher level themes. And in this case, the theme really is that BlackRock LifePath TDF investment strategy is one that protects against inflation. So these TDFs offer specific, they have a composition that allows them to hedge against inflation, so to speak. So in bull markets, they may underperform against, pure equity funds that are going to do really well when the market is doing well. But in a down market, they're going to beat out competing funds that have more equities. And I think here it's very, very important to highlight for courts that for fiduciary, considering a strategy for the investment funds in their plans, it is very reasonable for them to be concerned about downside risk. Their participants, they're not investing play money, they're investing their retirement money. So having that inflation protection built in that enables a fund to maybe underperform in a bull market, but perform better in a down market is something of real value to plans. So those are some of the themes we're seeing in these cases and in other investment fund cases. And with that, I'm going to turn over to Erin to talk about governance best practices.
So I think in this environment where we have seen cases, and when you put them all together, it's plaintiffs have essentially claimed that virtually every major TDF series is imprudent. If markets are up, the less aggressive glide paths were imprudent. If markets are down, the more aggressive glide paths were imprudent. So in the midst of this climate, what practices should plan fiduciaries adopt? So next slide. So at the end of the day, it's really comes down to process. It's well established that fiduciaries aren't required to guarantee successful results, but they must employ a prudent decision-making process. I want to remind folks on the phone that the Labor Department has actually published guidance for fiduciary committees when looking at TDFs. It can be found on the Labor Department's website. It's like their tip sheet for planned fiduciaries. And again, the tip sheet emphasizes the importance of process. First, as a starting point, the Labor Department has said that you need to establish a process for selecting the TDF and comparing the TDF with other choices, and you need to establish a process for reviewing that TDF periodically. So it is a prudent expert standard that fiduciary committees are expected to follow, not a prudent layman standard. It's critical to document that your procedural prudence. So next slide.
And can I just interject one thing about that, Erin? From the litigator's standpoint, process is both a shield and a sword. So, and what I mean by that is plaintiffs maintain consistently, they maintain that they have no way of knowing what the process was that the fiduciaries engaged in, and they need discovery. And so it's a bit of a chicken egg, because they have to have, to bring a lawsuit, they have to have a good faith basis. And here they are saying, well, we can't possibly know what the process is. It can also be very difficult on a motion to dismiss to bring the process to the court's attention. And you can have courts that will say, well, because process is the standard, we're going to let the case go into discovery. But as you've seen from the earlier part of today's program, there are a number of decisions that are throwing these cases out as not even getting over the threshold for evaluating the process engaged in. And that's really what we're after.
Yeah, that's right. So this slide just again summarizes what we mean by process here. So you need to, really, I think we've seen a rise in popularity of hiring consultants and other advisors who come regularly to fiduciary committee meetings. As shown on the next slide, on slide 28, it's really critical that the record shows an engagement with the consultant. There's really should not be just a simple rubber stamping of a consultant's advice to the committee. You would like to show in the minutes that there were meaningful questions. And so I think that's really an important part of the process. So next slide, please. This is one of my, this was a really interesting case to read, the NYU case, in terms of what committees really should not do. And really, the way the facts were laid out, it showed that the committee here was fairly, was asleep at the wheel. And at the end of the day, they just they deferred entirely to the consultant's advice and expertise. So it's important to keep that in mind. Next slide, please.
Erin, it's worth pointing out that notwithstanding the judge's lack of patience with NYU's naivete, that NYU still went on to win the case.
Good. That's yes. At the end of the day, it's good to prevail. But when you were the court, you wouldn't want to be one of those fiduciary committee members. I think that was highlighted in the in some of the dicta in that case. So
Right. That was not a good day for her in the courtroom.
That's right. That's right. So ERISA, of course, does not require the lowest cost approach. It's clearly no. It's a multifaceted decision. Many factors, fiduciaries consider many factors with respect to making their decisions. Of course, relevant factors include perhaps quality and experience, of the service provider, even when it comes to an investment product, the track record, the proven track record of performance, and that may come with higher fees. So I think that it's definitely a multifaceted approach, and thankfully the courts, as well as the Labor Department, has recognized this. So next slide, please. So selecting record keepers, I think, again, you can select a record keeper or another service provider if, and that you don't have to pick the cheapest one, of course. You can, again, go by reputation. But here's where I really would like to insert the importance, especially today, of diligencing the cybersecurity practices and procedures of your record keeper. It's another topic of litigation, but there have been cases suing record keepers, very sad cases where people lost their 401k plan participants lost all of their savings. So very important to go on the record and ask and due diligence on this point. Ask the amount of cyber liability insurance that the record keeper maintains, as well as all of the other service providers for the plan. When you're negotiating record keeping agreements, again, these provisions are critical. Cyber guarantees, what happens if there's a cyber breach, how are you placed on notice, and the costs, if there are costs and losses, what type of indemnity. These are very important factors nowadays for plan committees to really focus on and really not forget to issue spot. Always, effective communications with participants are really important in terms of, I think it has come up sometimes for fiduciary committees that have permitted record keepers to use plan participant data and offer other wellness service. Very important that these are not programs that have been vetted by fiduciary committees. So it's always incredibly important to look at that. DOL investigation risk. The Labor Department has announced earlier this year that a top enforcement priority for them right now, again, is cybersecurity. And so it has become, these questions have become a standard part of Labor Department audits and investigations. So inquiring and doing diligence on insurance and cybersecurity, there was guidance that was granted by the Labor Department last year, is absolutely critical right now for fiduciary committees. So next slide. I just wanted to touch a little bit on this because I've seen sometimes prohibited transactions come out of this issue of plan assets. The plan can pay for only two things: paying benefits or reasonable expenses of administering the plan. Next slide. It is very important for all fiduciary committee members to understand the distinction of settlor functions, which are establishing and amending the plan, terminating a plan, or considering plan design changes. Should our 401k plan have a match? Those are not subject to ERISA's fiduciary standards. These are what we call plan sponsor decisions, settlor decisions. And so they're outside of the fiduciary realm. And plans cannot pay for costs associated with settlor activities. these have to be paid by the plan sponsor. So if you need to hire, your benefits counsel to amend your plan documents because you're making a plan design change or adding a participant match, that those legal fees cannot be taken out of plan assets. So really important to remember this, because I feel that oftentimes after the fact, committee members, these errors come to light. Fiduciary activities do include selecting and monitoring your service providers. Again, your 321 consultant, your record keeper, other investment managers or advisors or OCIOs, your investment fund choices, as the litigation makes very, very clear. And of course, adopting and monitoring those investment policies that have been adopted, investment objectives, as well as asset allocations. Does the asset allocation of a plan make sense, given, maybe increased volatility in the market? For example, fiduciary committees have to periodically continue to take a look at those documents. I also periodically get asked to look at investment policy statements. I think, Nancy, Brantley, love to hear your 2 cents. It's a balancing act between having enough guidance in the IPS, but not getting into too much detail, because, and where it could create footfalls for the committee. I think plaintiffs do seize upon these IPSs, and if they think, or they may make allegations that a fiduciary committee departed from the IPSs, didn't meet like X number of times a year. If an IPS says they'll meet 6 times a year, they didn't meet 6 times. You don't want to put too much detail in the IPSs.
I think that's right, Erin. However, the one thing that I always instruct is, because there is no requirement under ERISA to have an IPS, if you do have one, and I think it's a best practice, be sure you adhere to it. The types of situations that we run into that are most concerning are when the plan does not pay any attention to what the IPS instructs. That said, however, rarely have I seen a plan fiduciary faulted on the theory that they didn't comply with the IPS. Typically, the IPS will be deemed to be guidance, not a charter, not the law of the plan. But if you are going to have one, don't just put it in the drawer. Make sure that it is reviewed periodically to make sure your investment choices are consistent with them.
That's great. Thank you, Nancy. And I think, unfortunately, we're not going to have time to cover arbitration and class action waivers, but look out for future guidance and programs from us on that. I think it can cover probably its own session.